Most people think YouTube is just YouTube, but the truth is the company behind the platform is Google LLC, which itself is owned by Alphabet Inc., one of the largest corporations in the world. And here's the kicker. YouTube is a private business, not a government service. That means the rules you follow here aren't constitutional rights. They're corporate policies. Today, I'm going to break down how YouTube is governed, what fair use and the First Amendment really mean for creators, what civil rights laws actually apply to private companies like YouTube, and what you can do when platforms are biased. YouTube is not a standalone company. It's a service of Google LLC, which is a subsidiary of Alphabet Inc. Alphabet is the umbrella company that controls Google Search, Gmail, Android Maps, and YouTube. So when you agree to YouTube's terms of service, you're not entering into a contract with YouTube, the brand. You're agreeing to the rules set by Google LLC, a Delaware corporation. That matters because when you think about your rights on YouTube, you have to think about the rules of a private corporation, not constitutional protections. One area that confuses a lot of creators is fair use. Under 17 USC 107, fair use is a legal doctrine that lets you use parts of copyrighted works without permission, but only in limited ways, like criticism, commentary, teaching, news reporting, or research. Let's break down what a legal doctrine means. Legal doctrines are fundamental rules, principles, or theories that guide legal reasoning and decision-making in specific areas of law. They are often derived from past court decisions and are used to interpret laws, resolve disputes, and establish legal norms. Think of them as the building blocks of legal systems, providing a framework for how laws are applied and understood. In terms of fair use as a legal defense to a copyright violation claim, judges look at four factors. 1. Purpose and character of your use. Is it educational or transformative, or just a copy? 2. The nature of the work. Is it creative or factual? 3. The amount used. Are you using a clip or the whole thing? 4. The effect on the market. Does your use hurt the original creator's revenue? Here's the catch. Fair use is not a right. It's a legal defense. If someone sues you, you raise fair use in court and a judge decides case by case. Let me reiterate. Fair use is a legal doctrine that permits limited use of copyrighted material without permission from the copyright holder, primarily for purposes like criticism, commentary, news reporting, teaching, scholarship, or research. This doctrine is not explicitly defined in a specific list, but is determined by a judge based on four factors. 1. Purpose and character of the use. This considers whether the use is commercial or for nonprofit educational purposes. Transformative uses are generally favored. 2. Nature of the copyrighted work. This considers whether the work is creative or factual. Creative works receive stronger copyright protection than factual works. 3. Amount and substantiality of the portion used. This examines the quantity and importance of the copyrighted material used. Using a small, non-essential part of a work is more likely to be considered fair use than using a large central portion. 4. Effect on the market. This assesses the impact of the use on the potential market for the copyrighted work. If the use harms the market for the original work, it's less likely to be considered fair use. Important things to consider: fair use is not a guaranteed right. It's a defense against a copyright infringement claim, and judges decide on a case-by-case basis. Using the heart of the work weighs against fair use. Even if a use is fair for one semester, repeated use may not be if it could be licensed instead, according to UMGC Library. You should understand the relevant law and potentially seek legal advice whenever necessary before using copyrighted material. Fair use is a complex area of law, and the specific circumstances of each case are critical to determining whether a use is fair. Now let's talk about the First Amendment. The First Amendment protects you from government censorship, not from companies like YouTube. Think of it like this. On a public street, the government can't stop you from speaking your mind. But if you're in a private store, the owner can ask you to leave for saying something they don't like. YouTube works the same way. Its rules come from Google's community guidelines and terms of service, not from the Constitution. To give creators some flexibility, YouTube has its own policy around educational, documentary, scientific, and artistic content known as EDSA. This sometimes allows limited use of copyrighted material if the content is truly transformative. But remember, this is YouTube's policy as a business. not the same thing as the legal doctrine of fair use. Here's where a lot of people get confused. Constitutional rights, like free speech, mostly protect you from the government. Civil rights laws, on the other hand, apply to both government agencies and private companies in certain areas. For example, under Title VIII of the Civil Rights Act of 1964, private employers can't discriminate in hiring or firing based on race, sex, or religion. Under the Americans with Disabilities Act, companies must provide reasonable accommodations for people with disabilities. Under 42 U.S.C. 1981, every person has the same right to make and enforce contracts, and that includes business relationships with corporations. So while YouTube can remove a video for breaking its rules, it cannot legally refuse to pay you or block you from monetization because of your race, religion, or gender. That would be discrimination. And we've already seen creators push back. In 2018, a group of LGBTQ+ creators sued YouTube for unfairly restricting or demonetizing their videos. While courts dismissed parts of the case, it raised serious questions about algorithmic bias. In 2020, Black creators, including Khadija Mbao and others, spoke out about their content being suppressed, compared to non-Black creators covering the same topics. In 2022, a federal judge allowed a lawsuit under 1981 to move forward, where plaintiffs alleged YouTube discriminated in how it applied its monetization rules. These cases show that while platforms are private businesses, they can still be challenged under civil rights law when bias affects contracts, payments, or access to services. So what can you do as a creator? Know your rights. Fair use is a defense, not a permission slip. Document bias. If you believe you're being unfairly demonetized, save evidence. Appeal using the right language. Reference YouTube's EDSA policy when it applies. Organize. Collective pressure has always been the strongest tool for civil rights progress. Remember, YouTube is a private corporation. They write the rules, but we're not powerless. By knowing the law and by working together, we can push for fairness, transparency, and equity in how these platforms treat us. If this breakdown helped you understand the business of YouTube, fair use, and your rights, hit that subscribe button and share this video with other creators. Because the more we know, the harder it is for big corporations to silence us.